Acting Attorney General Faris Al-Rawi said it was prudent to include a definition for the official receiver in the company's Amendment Bill 2022, taking into consideration the allocation of state resources. Mr. Al-Rawi said a lacuna or gap was noticed in the legislation while preparing for the full digitalization of the company's registry department.
And it says, for the purposes of this act, official receiver means the official receiver attached to the court for bankruptcy purposes and includes an assistant official receiver. Now, even though Section 366 says that the definition is for the purposes of the act, architecturally, from a drafting perspective, the advice is that we ought to put the definition of official receiver into Section 4 of the parent law.
Mr. Al-Rawi said the official receiver should also be known as the Chief State Solicitor. But Opposition Senator Jayanti Lachmedial pointed that rather than burden a single individual with the many proposed responsibilities, some investigative, the already established Office of the Supervisor of Insolvency should fill the role. While under the purview of the Ministry of Finance, the Insolvency Supervisor will act as a chief regulator.
Is it not better for us to utilize, for example, the Supervisor of Insolvency, who has the task of licensing persons who will be insolvency practitioners and trustees and so on? Would it not be better to have the Office of the Official Receiver seated in that regulatory authority?
Meanwhile, Independent Senator Dr. Varma Diyal Singh found merit in Senator Lachmedial's suggestion that the role should be filled by the Supervisor of Insolvency.
Put that office in the Supervisor of Insolvency. This might be something for further debate. This might be something for future, for the AG in the future to see, could we bring this in to give it appearance at least of a greater independent role.
The company's Amendment Bill 2022 was passed in the Senate. Kimberly De Souza, TTT News.